The Miranda Warnings. Created in 1966 by the United States Supreme Court, these are a list of warnings that need to be read to somebody while they are in custody being interrogated by a police officer. Those rights include: you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you. Do you understand these rights that I have read to you? With these rights in mind, do you wish to speak to me? These rights, or warnings, are important because they need to be read to somebody while they're in custody, while they're being interrogated by a police officer. The Miranda rights are not rights against being charged or arrested. They are evidentiary, and that evidence is your statements. This means that if you are in custody, if you are being interrogated by a police officer, these statements need to be read to you before your statements can be used against you. That said, there are times when people are in custody and blurt out statements without being interrogated. Those statements can be used against you. If you're not in custody and you speak to an officer, those statements can be used against you. If you think you have a Miranda issue in your case, be sure to speak to a qualified attorney. Feel free to give me a call. Guss Markwell at 636-486-1093.